Good afternoon and welcome to Real Divorce Talk San Diego. My name is Lynn Waldman. I am a divorce coach and therapist, and these are my co-hosts for today, Shawn Skillin, family law attorney, and Mark Hill, certified divorce financial analyst. Today we're going to be talking about your new family finances post-divorce and what it looks like, how to talk to the kids, and how to get along with your new co-parent and in your new life. So, Mark, I understand that as it's getting toward the end of the year, you've received quite a few phone calls and people are anxious with the new tax laws coming up and how it's changed spousal support. Can you please tell us about that and what do the time frames look like?
Yeah, the tax law that was passed last December basically took away the ability to deduct a spousal support payment by the payor. It was basically a deduction at, one presumes, the higher wage earners level, and then it was taxable at the lower wage earners level. And in fact, I'm working on a case right now. I can give an example of how significant this can be. On $10,000 of support, so it's a higher dollar amount case, but on that $10,000, it was going to cost husband about, after taxes, about $5,300. But wife was actually going to receive nearly $7,000 because she was in a lower tax bracket. That's all going away. So basically, any support payment after, for agreements that are not made in this calendar year that go into 2019, will then basically not be deductible to husband or taxable to wife, but that takes away some of the tax advantage and it's going to make our divorce cases more difficult. And I've had a number of people contact me in the last week saying, hey, we realize this is up, we need to get this done now. My concern is what kind of bottleneck are we going to get in the courts? And so my question for Shawn is, how can we address this?
So two different issues. The first one is, can you still get in under the wire by December 31st, 2018 and maintain the spousal support deduction for the person who's paying support? And the answer is yes. Even though there's a 6-month waiting period to get your divorce, there's no waiting period for a legal separation. So if this spousal support deduction is really important financially to your family, then what you want to do is hot-foot it down to your friendly divorce lawyer's office and get filed now and file for a legal separation, which has no waiting period, and you can get everything done by the end of this year. The other option would be to file a divorce, and even though you can't enter your judgment and terminate your marital status for at least 6 months, you could enter a partial judgment on support before the end of the year and preserve that spousal support deduction and then finish the rest of the divorce at your leisure. If you get your judgment in, either a judgment, partial judgment on support or a judgment of legal separation by the end of this year, then you preserve that spousal support deduction going forward forever. Anytime that spousal support has to be modified or changed in the future, you can still have it be deductible. If you don't get it done by the end of this year, then January 1st, 2019, spousal support will no longer be deducted for the person who's paying it. Now, the person who's receiving it won't pay taxes on it, but the amount you're receiving is going to go down because there's the higher taxes are going to be paid by the payor, which means they'll have less money to pay you in support. So that's the first question, is legally, can you still get it done? And my answer is yes. The second question is, what about the backlog in the courts in San Diego? Anybody who works in the divorce area in San Diego knows that it takes a long time to get your documents processed once you've sent them down to court. So what does that mean? The courts know this is all coming. So there are going to be what they call judgment walkthrough days towards the end of this year. They should be starting to set them the end of November and into December. So each family court in Vista, South Bay, downtown, and El Cajon will have judgment walkthrough days. In order to get your judgment walkthrough, first you have to have it done. So you have to get filed, you need a case number, you need to be assigned to a judge, and you need to make your agreements so that they can be written up and got ready. So all of the stuff has to be down to the court at least 10 days in advance of any judgment walkthrough day, and each court will have a different day. And then you pay a special ex parte fee. to have them processed. And I want to say the ex-parte fee is $60, so it's not exorbitant. So this all can be done, but you have to be planning in advance, because if you miss the judgment walkthrough days, it's just not going to happen. So if that's what you're interested in, contact me, Shawn at ShawnSkillinLaw.com, or just go to my website, ShawnSkillinLaw.com, call Mark or whoever, and just get things rolling.
So this sounds really complicated, and it sounds very technical. So I would like to ask our listeners and our viewers, if you have questions, please write in. We'd be happy to answer your questions as much as we possibly could. And so, Shawn, I'm really glad to hear that it's not too late, because I was under the impression that at this point, if people haven't filed, then they would be stuck with the consequence of the new tax law. So it's good to hear that that's not the case.
Right. So people get confused because there's a 6-month waiting period with the divorce in California. But that waiting period really only applies to your status as whether you're married or single. You can enter a partial judgment. We can do a legal separation, so there are some ways around it. But because we need to make the walkthrough day dates and we don't exactly know what they're going to be, I'm telling my clients that we need to have your agreements written in writing and ready to sign and make copies and get down to the court by November 1st.
So would November 1st be like the very last day that people could file to still get the
No, they
current
need to be
tax?
filing now. They need to be filing now, because we need to get a case number, we need to get assigned to a courtroom so that we know what walkthrough date we're looking for. And in the meantime, we need to be working through the agreements, running DISO masters, doing financial disclosures, all of those kind of things, so that by December 1st, November 1st, everything's done and ready to go to the court. If they're trying to start on November 1st, it's going to be real challenging to get it done by the end of the year.
Thanks. That's really important. I think that everyone gets the message that this needs to be jumped on right now.
Yeah, right now.
If you're considering doing this, if there is a disparity in income between the two spouses, and that's really what we're talking about here, where it's significant and it's a longer term marriage, so there's likely to be support, you need to address this right away. Don't delay even a week. You need to get into the pipeline, because we're all getting busy. Because everybody's suddenly waking up to this fact, and they all want to get things done this year, and we all have limited bandwidth.
Yes, because the news has been out there for quite some time, but now as we get closer to the end of the year, it sounds like some people are starting to panic a little bit.
And people don't understand that this is a process, not an event, getting divorced. It's not, you don't say, I'm going to get divorced, and then a week later you're divorced. There's a lot of things that you've not even considered that will have to be agreed in this process. And even if we're just talking about support, it's a smaller piece of the pie. I get it, but at the same time, it's still in part of the negotiation, and you need to understand what you're agreeing to.
And this is something that, like you were saying, Shawn, it certainly could impact people and their finances for many, many years.
Oh, yeah.
Yes. For people who are higher earners especially, that spousal support deduction and shifting the tax burden from the person who earns more to the person who earns less. In Mark's case, you're talking a couple of $1,000s a month that you're saving for your family that you're not giving to Uncle Sam. So for some families, it's $30 a month, and maybe they don't care, but for them, that $30 a month might be important. But if you're a higher earner, the higher earner you are, the more of a tax savings it is, and that's going to go away January 1st, 2019. So that, that is an urgent piece. Spousal support is subject to modification. So if you can get the judgment in, even if it's going to change, go up a little, down a little later, that's fine. You're not locked into that number forever. And once you change it after January 1st, 2019, it can still be deductible. It's just the original order or agreement has to go in by December 31st, 2018. And spousal support is a complicated matter, because it, filing and taxes and all of this stuff. So you probably not only need to be involved with your divorce attorneys and your divorce financial analyst, but you probably need to get your accountant on board too, to make sure that everything that you're doing is going to make sense, not just this tax year, but going forward.
And what about child support? Is there any implication or impact for child support with the new tax laws and needing to file right away?
No, there's no impact around that, because it never was deductible to the payor or taxable to the payee. So no, that has not been changed. Basically, it's made spousal support like child support in a way.
true, but I think because the higher earning spouse, who's probably paying both the child support and the spousal support, will no longer have that spousal support deduction, they're going to have less money available for support overall. So your spousal support's going to go down and your child support's going to go down because, well, we're going to talk about child support in a minute. Well, let's just drop right in. Child support is calculated based on a guideline formula in the state of California. And to oversimplify it, you put in each person's gross income and certain allowable tax deductions, which also got changed last year. Things like mortgage interest, property taxes. We look at how much money do you put into your 401k, how much money comes out of your check or you pay out of pocket for health insurance, because that all affects your taxes. And the guideline child support formula is a tax-based formula. So then it, runs through and does its little calculations and it spits out a number. And because it is able to compensate for the tax effect of the spousal support, that is going to affect your net income, how much income you have left in your pocket after you pay your taxes. And so your child support may be going down too once that spousal support deduction is lost. So that's kind of how the child support guideline works. And then when you're in court in California, the judge must order for child support the number that pops out of that computer. If you're in mediation or you're doing a collaborative divorce where you're negotiating your divorce settlement out of court, then you must be told what that child support guideline number is. But then you can have a discussion with your soon-to-be ex-spouse and decide, are you happy with that number or not happy with that number? So you can agree to a number that's higher or lower. You still have to say in your divorce agreement what the guideline number would have been, what the amount is that you're willing to pay now or you've agreed to pay, and kind of why. But you can get that through the court as long as you play by all the rules. So you do have flexibility outside of court. Inside of court, you might argue a little bit about what goes into the formula, but once they push the button, the court is obligated to order the guideline number. Now, that guideline number that pops out of the computer is what we call your base child support. And let's say that's $500 a month. To that, there's two mandatory add-ons that the court has to add on to that $500 a month. And those two mandatory add-ons have to do with child care that you have to pay for either of you to work or to obtain job training for work. And the other is daycare for your minor children. And those are usually split 50-50. If after support is paid, one of you still has a lot more money in your bank account than the other, then the child care and the uncovered health care expenses can be split proportionally. But generally, the incomes are pretty even after support, and it's usually split 50-50. So that's kind of how the child support guideline works. And again, your certified divorce financial specialist or a lawyer can run those numbers for you. I would caution you about going online to run numbers. There are a bunch of different child support calculators out there. Some of them are more accurate than others. But you can kind of get off base and think, oh, your support's only going to be this, or the other person can think, oh, I'm getting all this money, only to find out that your number was way off by several $100s a month. So it's worth it to either go down to the court and run the guideline or to call somebody who knows what they're doing and get the number run.
So again, all of this sounds super complicated, so I could see why it's going to be really important for our viewers and our listeners to really get some expert advice. So please remember, if you have questions, write in. And Mark, please tell us, what is your phone number if somebody wanted to reach you, and your website or your email address?
Yeah, my company is Pacific Divorce Management, and the phone number is 858-509-2320. And our website is pacdivorce.com, PACDIVORCE.
Great, great. So if people have questions, they certainly could call either one of you. And when people don't agree, like Shawn, you were mentioning a few moments ago, that clients could, either in mediation or through collaborative divorce, try to work out the numbers. What does that do as far as getting to the point of an agreement before the end of the year so that they do get that tax advantage? What if there's just a lot of disagreement?
I think you can compartmentalize it at this point, and if there's a contentious divorce, that's what I would urge clients to consider doing. Get something, Shawn I think put it really well before, get something into the system where it's a number. Yes, it has to be based around some reality, but it's modifiable. And I would suspect, Shawn, that we could actually put something in that says this will be addressed based upon, future change of circumstances, or this will be looked at annually based upon circumstances. Can that be written into an agreement so that we can have the ability to revisit?
Absolutely. I do that all the time in my mediation and collaborative cases where we write. In fact, I've got a case right now where her husband just had a change of employment. So we've written in what the support numbers are now, and we've agreed to come back in November to revisit them again later. So that's something that's commonly done. The other thing I just want to tell our viewers is that the only way you're going to get this done right now by the end of the year is to do it in mediation or collaborative, some kind of out-of-court settlement. Because if you want to file now and think you're going to get a court date where a judge is going to run these numbers for you, that is not going to happen before the end of the year. They just book way too far out. So the courts, unfortunately, in San Diego County are backed way up. If you're in Riverside County, Orange County, LA County, check with a local attorney there because their timelines are very different, but San Diego is way behind. The only way that you're going to be able to get that done is to get an out-of-court settlement.
I have a case in Palm Springs right now.
Yeah.
They're saying it's got to be in by September 30th.
Yeah.
So some places are worse than San Diego is what we're hearing.
Wow.
So,
Yeah. So and I just would say that the three of us on this panel, we all function in the divorce world here in San Diego by doing mediated cases and collaborative divorce cases. Our goal is always to try and keep you out of court and make this transition as easy as possible for you and your soon-to-be ex and your children, and to also make it cost-effective. So always consider trying to get an out-of-court settlement going.
I agree, and I would just jump in with one thing there to say essentially that having resources at the table is essential to getting this done in the short term. So as Shawn said earlier, get your support system up. Make sure that you have an accountant or your accountant available. Make sure that you have people to help you through this process, because my concern and fear is that as we go into 2019, cases become much more difficult to settle, just because we're taking away resources from the family by this tax law change. And that inevitably, everybody feels poor after divorce. Two households cost more than one. This is not going to make things better. And the more we feel stressed and the more we feel that our resources are under pressure, the more difficult it is for us to be generous. And I can just see this being much more contentious. So I think that alternative dispute resolution, whether it be collaborative or mediation with people that are there getting you through the process as opposed to, quote, defending your rights, is going to be very important.
And Mark, for our viewers that are not familiar with collaborative, could you please give us a brief explanation of what collaborative looks like and what clients could expect with collaborative?
Surely. It's, to try and do it simply, it's mediation with resources at the table. So it's a team-based approach to divorce where both sides has their own lawyer, essentially making sure that their interests are protected and that they understand what they're doing. Each side has a mental health professional, not trying to save the marriage, but essentially communication coaching, make sure they can talk to each other. And then the role that my profession adopts is the neutral financial advisor, who essentially gathers all the data, puts together a financial report, gets agreement from both spouses about what the financial issues are, and kind of, when you sit at a table with all these resources at it, my role is to sort of moderate and facilitate that meeting because I'm neutral. I don't really have a dog in the fight on either side.
And it's a client-driven process where the clients are negotiating with the support of their team.
Correct.
For the sake of the family.
Correct. And it's candidly, it's the only model that I know that gives a voice to the children. Because if there are children, minor children, they will inevitably have a child specialist who will meet with the kids and talk to the parents about what the kids are experiencing and give us some input from that side. And you don't get that in any other model.
Yes, and that's one thing I like about collaborative is that the voice of the children is at the negotiating table.
Yep.
And that can make a
Well,
difference.
and I think the family is given an opportunity very early in the process to work with you as the coach and the attorneys to kind of set their mission statement for the divorce and set their goals. Like what are they really concerned about financially, with the children, with how involved they want to be with each other post-divorce. And so it really is a client-driven process where you can control not just the outcomes of what happens at the end of the divorce, but you You set your goals from the very beginning and decide how quickly you're going to move through the process. And it is difficult. It's a huge transition. And having the resources of the coach, the lawyers to take care of the legal stuff, the financial person who can give you the short and long-term views of what your new family finances are going to be looking like, really just gives you a lot more information and a lot more of the ability to come up with a solution that really works for your family. So, mediation is a great alternative too. You can also have, a therapist that you work with outside of mediation. You can have consulting attorneys, and you can still work with somebody like Mark, but with collaborative, the team is built in. So either one of those are great options, much better than a knockdown, drag out in court.
Yes, certainly. And we'll get to a resolution much quicker, and the family finances, hopefully, or resources would still remain intact.
And you maintain control over the timing too. If you've ever had a court date, you show up on the court date. You can't say, I'm sorry, the business doesn't work for me that day. You might get a postponement, but candidly you don't want one because it'll be months down the road because our calendar's so busy. So you get to kind of define when the meetings occur.
So Mark, there's a question up there for you about does Pacific Divorce have any divorce options workshops?
Well, divorce options workshops are essentially put on by the Collaborative Family Law Group of San Diego. And yes, we do them every month. We do them the first Saturday of every month. And I have presented in the past, and I presume I will present in the future, but we kind of rotate through the different professionals that actually do that.
Yes, and the next divorce options workshop is October 6th, and it's from 9 to noon in Carmel Valley, and where we will have a certified divorce financial analyst, a family law attorney, and a divorce coach, and we will be talking about how to divorce, because we like to think that once you have decided to divorce, the next most important question is how do you go about it. So we will go over all the options, and we discuss the finances, the legal aspects, and the emotional aspects of divorce. So please keep your questions coming. We're happy to answer questions. And
so Lynn, speaking
yes.
of three professions being involved, we've talked about the spousal support and some of the child support stuff, but I think the most common difficulty that a lot of my clients face once they've gotten divorced with the new finances is that there is less money for the same two households, and when you have children, your children are used to a certain standard of living also, including playing travel soccer or getting a new surfboard every once in a while. And so parents are always challenged with talking to their children about what the new financial situation looks like. And they're really concerned about having to say no to their kids if they have to give up certain activities. So as a coach, what kind of advice can you give our viewers?
Well, I would say that, even when you were married, you couldn't give your kids everything they asked for. So even as a married couple, there were limits. So now, having two households, yes, finances change, and typically the standard of living is lower when there's two households. So I think when kids want things, it kind of opens it up to have a discussion about what finances mean and what finances look like. It could be a teaching moment for younger kids. Offer options, I think, is a good idea. If a child wants something and you're not able to provide it and don't have the same finances, I think it's a good idea to talk about what else is out there, or possibly saving for the future if this is something that's really important and they would like to have. It gives the opportunity to talk about their feelings about it, about being disappointed. So really the parent can be the role model for how to go on with life when you can't have everything you want.
Have you seen I've seen a couple of situations in cases where the person that wanted the divorce feels guilty about it, and their mantra is the children cannot suffer. I can live under an underpass, but the kids must still have their riding lessons. That kind of approach because of how the divorce came. How do you address something like that in your counseling?
Well, we'd want to talk with that parent to help them see that definitely, you know, we want to provide for the kids. And I think what children generally want is to feel safe, to know that their parents are going to continue to love them. So I think that almost becomes more important than the lifestyle. To know that they're safe, secure, mom and dad are always going to be there, they'll always have access to both parents. So in those kind of situations, it is more about that parent who's feeling guilty. And sometimes it's difficult to let go of the guilt. But again, I would turn it around to what is the conversation you could have with your child, because it's not so much about the activity or the event, but it's more about that parental connection and helping your child deal with feelings that might be uncomfortable or when they have disappointment. And that parent as well may want to seek out counseling to get some support for that.
And Shawn, we often, when we're dealing with children, there are things that are kind of, we consider to be extracurriculars, but we can put guidelines in the agreement of how we're going to address those, can't we?
Yeah, so child support is really meant to cover, we always say, the expenses that happen under the roof of the house. So it's meant to pay your rent or your mortgage. It's meant to pay your utility bills, to buy the food, to put gas in your car, those general things. Things like paying for travel soccer or writing lessons or dance class are really outside the realm of child support and should be agreed upon by the parents before those expenses are taken on, because there are 2 new budgets to deal with. And so things may have to be adjusted. So we usually end up talking about that in a collaborative divorce or mediation case of how are we going to handle the extras that your kids may want or need, and who's going to pay for what. Is it going to be 50-50? If dad really wants them to play popcorn or football and mom just can't afford it, is dad willing to take on that expense? And families handle those things in all very different ways. Sometimes, you know, there's enough money to go around that's like, yeah, whatever, just let me know, I'll reimburse you for half. Others put X number of dollars into a joint account that's earmarked for the kids, and rather than bothering each other for reimbursements for co-pays or whatever, they just each have a debit card and they use that to pay for kid expenses, and they agree what's covered and what's not. So there are a lot of things that come up, you know, beyond the basic guideline child support that have to be addressed with your kids. And of course, if you start out getting divorced and your kids are 5 and 7, you know, those issues are very different by the time they get to be 13 and 15, 16, and they're driving a car and they need car insurance and things like that. So all of that stuff has to be talked about. And, you know, I don't know, Mark, my personal thing is that you should start teaching your kids about finances. My kids got checking accounts when they were 16 and had to learn how to balance them. And so this kind of, I think, old-fashioned mantra of don't discuss the finances with your kids is maybe a little outdated. Should they be panicked over finances? No, I think you need to reassure them that everybody's going to have clothes and food and a place to live. But I don't know, you're the financial guy. Shouldn't kids have a realistic concept of if you put the card in the thing, the money only comes out if there was already money in there?
I think back to the time when my son, when his mother and I were newly divorced, and I think he was about 4 or 5, and I pointed out to him I didn't have the money to buy something. His response was, well, Dad, put it on a credit card. You know, so yes, I think educating children is really important, and our educational system does a terrible job of financial education. But I think that what happens is it's the protection of the children. I want to protect them from this problem I have with my spouse. I don't want them to be a part of it. And there's money worries, I want to protect them from that too. And I think the education is largely to the parents to say, you know what, your kids are smart, they're of an age where they can understand at least the basics of this, and you're doing them a disservice by not helping them understand this a new reality. I mean, the kids just, as you said before, they just want to know that mom and dad are going to be there and they're still going to love them even if they're going to stop loving each other. That's all they want. And often children will surprise their parents by becoming almost more, you know, I had a case literally this week where mom tells me that one of the kids is putting like his new underwear he had to buy on his credit card, that, you know, he's going to pay for, and she's like, no, we'll still pay for that. So again, sometimes the children will actually go beyond that because they're worried for the parents. That's one thing that's universal. They're scared for you guys. Are you going to be okay? you know.
And I think you're right. There has to be a good balance where you're kind of shielding your kids because they don't need to know all of your financial worries. And at the same time, it's good to learn a little bit of responsibility and what it means to take care of your own money and pay for things that are important to you that are not really necessary. They're more things that you want to have rather than need.
Yeah.
So there does have to be that balance. And I also caution parents not to scare your kids. I've had parents tell their children they're not going to be able to go to the same private school they went to because of finances. And that is stuff that you really want to be sure that you're talking with your co-parent about before giving children any kind of information that would be a little bit unnerving for them or changing their life more than they expected.
And that expression is often followed by, and it's all your mother's / father's fault, you know.
Right. Yeah, and that's definitely something we want to shield the children
Yes.
from, is blaming the other parents.
Yeah.
Because most likely in both homes, finances are going to change and be less than what they were.
Yeah, so I mean, it may be that you can't keep going to private school to the tune of, $20,000 a year or whatever, but it's a discussion that the parents should have and agree to, and then present to the kids as a unified front with the alternate plan, right? It's not like, oh, we're getting divorced, you can't go to your school anymore. It's like, you're going to change schools, and now it's going to be this. But I think just trying to work together as best as you can as co-parents. And I think what you talk to your 3-year-old versus your 7-year-old versus your 15-year-old about are going to be very different financial discussions also. And I'm sure you would agree.
Yes, and of course they're going to have much different needs. Like you said, the 16-year-old is going to want a car and car insurance and
gas money.
And yes.
And if they're a boy feeding,
Yeah, let's not talk about that.
they have hollow legs in my experience at that age.
Exactly,
Yeah.
Yes.
So I guess the other thing we can talk about in terms of, we mentioned it with the spousal support, that it's something that can be modified and changed, either through agreement or because of a change in circumstances. And I do want to say that child support is the same way. So while the initial child support order may work for now based on your finances and the amount of time that you each spend with the children, those things do tend to change over time. Somebody gets a promotion, somebody changes jobs. One person, all of a sudden, one parent's traveling a lot, so the other parent has the children more of the time. And anytime there's a significant change in circumstances, then your support agreements are subject to change, or what we call modification. So just know that whatever you come up with now can be changed if your circumstances change for the better or the worse. You're not stuck with those agreements forever.
And if you're not at a point where you can negotiate a settlement around support this year, we are working on a number of more creative ways of addressing this, using retirement funds, and actually, if someone's staying in the house, using a mortgage to still get some tax benefits. So we are working to try to find ways to alleviate this, but if you can do it this year and there is a big disparity in incomes, I would urge you to move forward and address it.
Yep.
This might be a crazy question, and I'm sure we don't know the answer, but any chance the tax laws are going to revert back to what they have been? I mean,
I'd say we should address that after the November election.
Yeah, I think so.
Yeah, I don't think that they're going to revert back under the current circumstances, but could they change again in the future? I think they could. I don't think most people even knew that this was coming. It was kind of buried in a huge tax bill,
And it was
all
done
kinda
so
came
quickly,
very quickly.
before the end of the year.
Once we all were made aware of it, we were, glued to our computers looking at every revision that came out. But I think the general public had no idea that it was happening. So
I think it's pretty unlikely. They've just come out with Tax Reform 2.0 in the House. Now it looks like they're not even going to vote on it, and the Senate wouldn't take it up before the elections. But the plan there was to make originally the corporate tax cut from 35% to 21%. That's ad infinitum. That goes forward. There's no sunset provision in that. But because it doesn't work for the budget, the individual tax cuts that were significantly smaller, those sunset in 2025 or 2027. I think it's 25. And because of that, what happens is that they have to change they're going to have to change spending to accommodate them. And what they're doing is now saying they wanted to make those permanent. and also the state and local tax deduction, which is important for people in California and some other high state taxes. That is going to be basically locked in for good too. So you ask, would it change? Well, if the balance of power changes in Congress to where the high tax states have some clout again, you may find that it would change, because there's a lot of frustration and anger certainly around what has occurred.
Yep.
Yes, yes. So
And, it's also possible that in California, because it is a tax-based guideline, that the legislature in California could take up the whole guideline formula and revise that. That would be a lot of work. There's no talk of doing that I'm aware of, but that's also a possibility. But for right now, we're stuck with what we've got, and we're trying to figure out, how to best work with it to benefit our clients.
Yep.
So I want to remind our viewers, our next Divorce Options Workshop is October 6th from 9 to noon. We can discuss some of these issues. We'll also be talking about your different options for how you can divorce. And our next Divorce Talk San Diego show is scheduled for October 9th at 1 p.m. We hope you will join us then. And please tell us your phone number and email or website once more.
Sure. Mark Hill, 858-509-2320, pactdivorce.com.
And Shawn Skillin, Skillin, ShawnSkillinLaw.com is my website, and my phone number is 619-299-4880. And Lynn?
And I am Lynn Waldman at lynnwaldmanlcsw.com, and my phone number is 619-865-3203, and happy to answer any questions. So we hope to see you at our Divorce Options Workshop October 6th at 9 o'clock.